Everyone. My name is Nancy Lopez, and I want to welcome you to the Supreme Court View from the Press Gallery. I'm the Executive Director of the Washington Council of Lawyers. We have, for 50 years, been the Public Interest Bar Association for the District of Columbia. Our mission is to strive to ensure our legal system treats everyone fairly, regardless of money, position, or power. Washington Council of Lawyers was recently named the Voluntary Bar Association of the Year by the DC Bar, so it's the perfect time for you to become a member. We bring together public interest-minded law students and lawyers from big and small law firms, in-house legal departments, government agencies, and nonprofits. Together, we strive to advance access to justice. We invite you to join our vibrant public interest community, and you can see in the chat how to do that. I also hope you will attend our upcoming events. We have Fellowships 101, Best Practices in Pro Bono, and a members-only discussion on post-pandemic workplaces. Again, you can register on our website, and that information is in the chat. Before we begin today, I want to go ahead and ask you to put in the chat your information about who you are and where you are today. And I'm also going to invite you to do that via a little poll. You can let us know where you're joining us from today, which time zone you are here. And then also, what's your connection to the legal profession? Are you a law student? Are you a legal services or nonprofit lawyer, a law firm lawyer? Where are you and what are you doing? It will help us see who's in the audience and tailor the conversation. I'll give people just another minute to log their response. And then we'll go ahead and see where people are from. A lot of people from the Eastern time zone, and then a lot of law students, probably from schools from all around the country. We are really excited today to have this panel of Supreme Court journalists who see behind the scenes how the decisions come together. You can follow our conversation on Twitter using the hashtag SCOTUSPress, SCOTUSPRESS. And we'll record this session so that if you weren't here today or you have to log out in the middle or you want to just watch it again, you can do that. Our moderator today is Art Spitzer. He's a senior counsel at the ACLU for the District of Columbia. He's been at the ACLU since April Fool's Day of 1980, and he has served as the legal director until April of last year. Over the years, Art has worked on a wide variety of cases and case areas: freedom of speech and religion, police misconduct, national security, freedom of information, privacy, prisoners' rights, discrimination, and lots more. The list of matters that he has worked on and interesting clients he has served is very long, so I will highlight just two of them. First, in the Supreme Court, Art successfully argued Aki versus Oklahoma, which ruled that poor criminal defendants are entitled to free expert witnesses when needed for their defense, just as they are entitled to free legal lawyers. Second, together with colleague Marsha Lowry, he filed LaShawn A. v. Bowser, a class action lawsuit to reform DC's dysfunctional foster care system in 1989. Art is tenacious. The case finally settled last month. Art came to the practice of the law via Brooklyn, where he was born, Queens, where he grew up, Cornell University, and Yale Law School. I'm very pleased to hand the screen over to Art and invite our panelists to join him there.
Thanks, Nancy. Yep, thanks, Nancy. If everybody would turn on their video, welcome everybody. Thanks for that lovely introduction. I should have made sure in advance that you knew how to pronounce my client's name in that Supreme Court case. He pronounced his name Ake against Oklahoma, just for the historical record. Welcome everybody. We're privileged to hear this afternoon from a panel of journalists who've covered the Supreme Court collectively for more than 100 years. That doesn't mean any of them knew Oliver Wendell Holmes. I'll introduce them in order of their tenure covering the court. David Savage has been with the Los Angeles Times since 1981 and covering the Supreme Court since 1986. He's the author of the latest edition of The Guide to the U.S. Supreme Court, published by CQ Press. David has degrees from the University of North Carolina at Chapel Hill and Northwestern. Joan Biskupic, in front of the bookcase, is a CNN legal analyst who's covered the Supreme Court for 28 years and has written biographies of Justices Sandra Day O'Connor, Antonin Scalia, and Sonia Sotomayor. Her most recent book is The Chief, The Life and Turbulent Times of Chief Justice John Roberts, published 2 years ago. Before joining CNN, she was an editor in charge for legal affairs at Reuters, and before that was the Supreme Court correspondent for the Washington Post and USA Today. She holds a law degree from Georgetown, and I plan to ask her later on what her next book will be. Robert Barnes, who's zooming in to us from Naples, Florida, where he just survived a hurricane, joined the Washington Post as a reporter in 1987. Since then, he served as deputy national editor, national political editor, and metropolitan editor. He returned to reporting in 2005 and began covering the Supreme Court in 2006. Bob had been planning to go to law school, but changed his mind after taking a journalism class as an undergraduate at the University of Florida. His biography on WashingtonPost.com says it did not occur to him, as it apparently did to others, that he could do both. But perhaps a better explanation is that he realized he didn't need 3 years of law school to not practice law. Adam Liptak took over the New York Times Supreme Court beat 11 years ago, but he has a much longer, I think that's 12 years ago now, but he has a much longer history with the Times, which he first joined as a copy boy in 1984 after graduating from Yale, to which he returned for a law degree in 1988. In 1992, he joined the Times legal department, advising the paper and representing it in litigation involving defamation, privacy, the right to news gather, and similar issues. A decade later, he became a reporter covering legal issues. His work has also appeared in the New Yorker, Rolling Stone, and many other publications. Amy Howe publishes Howe on the Court, a blog that covers the Supreme Court and the judiciary in, as she says, mostly plain English. She's also an independent contractor for SCOTUS blog, of which she used to be the editor. Before turning to blogging, she served as counsel in over 24 merits cases at the Supreme Court and argued 2 cases there, beating me by 1. She's co-taught Supreme Court litigation at Stanford and Harvard Law Schools. She's a graduate of the University of North Carolina at Chapel Hill and holds a master's degree in Arab studies and a law degree from Georgetown. Ariane DeVogue is a reporter and producer for CNN Politics, covering the court and legal issues and guiding network-wide reporting on legal matters. Before joining CNN in 2015, she covered the court and the nominations of several justices for ABC News. And as an investigative reporter, she's covered terrorism, the aftermath of September 11, Bill Clinton's impeachment, and campaign finance issues. She's a graduate of George Washington University. As you can tell from my introductions, this is not a panel of litigators, and we're not going to be analyzing case law, although we'll talk about it some. Our plan is to talk about the court as an institution and as a collection of individuals, and about covering the court as journalists. Feel free as we go along to post questions using the Q&A feature at the bottom of your screen as we go along. I'll try to keep an eye on it and ask some questions that are relevant to the topics we're discussing as they come up. In any event, we'll save some time for Q&A at the end. I hope you'll have questions in our last 15 minutes or so, if not before. So let me just start by saying, in some ways, the biggest news this term is what hasn't happened, or at least hasn't happened yet, the non-retirement of Justice Breyer at age 82, meaning that all of the panelists here may actually be able to take summer vacations this summer. Many commentators have been publicly calling on Justice Breyer to retire while the Senate remains in Democratic hands. Joan, you wrote a piece about this in May that included a fact about Justice Breyer's connection to a long ago Supreme Court resignation that I found interesting. Do you think that history may be influencing him now? Joan?
Thanks, Art. And hello to all my colleagues, and thanks to all the people watching this right now. It's always a pleasure to be here. You're referring to the fact that Justice Breyer was a law clerk serving Arthur Goldberg when President Lyndon B. Johnson strong-armed Justice Goldberg and got him to step down after just 3 years on the Supreme Court. LBJ was trying to find a spot for his old pal, Abe Fortas, and he effectively persuaded Justice Goldberg to be the U.S. ambassador to the UN, saying that, we're in the middle of Vietnam and you are an expert negotiator and you can help us negotiate our way out of Vietnam. Justice Goldberg said later that he very much regretted that decision, but Justice Breyer was there at the time, and Justice Breyer has all sorts of things to say about that era. I don't think he sees it exactly the same way in terms of filled with regret, but I think the one of many lessons he would take from that is you retire on your own terms. And I think that's exactly what we're seeing here. You referred to a May story, but I have to say, I and everyone else on this panel have probably written, 7 stories in the last weeks about what we can expect from Justice Breyer, trying to use all sorts of different angles. But my bottom line is still at this point that all the signs indicate that he's not going. I think that he's, first of all, I do think he probably believes he has until next year with the Senate majority being Democratic. That would make it easier for President Biden to push through his choice. Although we know, Art, that a lot of Democrats don't believe that one vote majority is that solid and reassuring. But I think Justice Breyer probably believes that at this point. And, this is, you had referred to the fact that he had an unusual term with a couple of very big decisions in Obamacare and in the high school cheerleader profanity case. This is the time around that he is the senior justice on the left, because Ruth Bader Ginsburg had that role from the start of his tenure, because she came on the year before, an appointee of President Clinton, a little bit more empowered. So I think he would probably like to have another one of those years, but it's tough to fully predict with confidence, as we have seen what many liberal activists and advocacy groups are doing to put pressure on Justice Breyer. And lurking in the background, of course, is what happened to Justice Ruth Bader Ginsburg, who rejected pleas to leave while President Obama was in office and had a Democratic majority. And she almost made it, but just a few weeks short of President Trump leaving office.
Some people have speculated that part of why Justice Kennedy retired was because he had a signal from the White House that his former law clerk, Brett Kavanaugh, would be nominated to replace him. Does anyone suspect that Justice Breyer might be waiting for Ketanji Brown Jackson to have a year on the DC circuit to make her a more likely candidate for nomination if he retires a year from now? She clerked for him. Bob, any
Well, I would just say, I think that, it's not, you don't have to look a whole lot further than the fact that Justice Breyer enjoys being on the Supreme Court. And as Joan mentioned, he gets to be the senior on the liberal side. He got great assignments this term. And, maybe he puts all sorts of calculations into it, and maybe he just really likes the job. And isn't ready to give it up quite so soon.
Well, speaking of Justice Kennedy, who retired a year ago, has anybody heard anything about him? Is he active? Does he still keep chambers and law clerks? What's he doing now that he's no longer the most important justice in the United States? Joan, do you know anything?
I know he's not sitting on cases right now. I think he's, I know he's given a speech or two. I was at one that he gave after he retired in Wisconsin with Justice Kavanaugh up on the stage with him. But I think he's pretty much receded from public life. Just a few things, certainly not as active as Justice O'Connor was in her immediate years after she stepped down, as she sat on cases, and obviously was very involved in iCivics. And David Souter sat on cases, and Justice Stevens was writing books. So it's not to say that he's totally disappeared, because he hasn't. He just hasn't been as active as some of his predecessor retirees that I've seen.
Speaking of retirements, the Supreme Court's public information officer, Kathy Arberg, retired this week after many years of service in that office. For an institution that's as opaque as the Supreme Court, right, all they do is hand down opinions, is having a public information officer an oxymoron? Does that office serve a useful function at the court? David?
Well, yes. Kathy was a good, honest broker. If you had a hard question, and she was a good person to check with. If you wanted to check some fact about the justices of the court, she would pass on a note. And I thought she did as good a job as you could do in that situation. The justices are not hiring somebody to go out and talk them up and give a lot of information. But I thought Kathy did a very fine job and a useful job. If you have a real problem and wanted a question, as I say, Kathy would give it a try. She would run it by one of the justices. And they also are very efficient at telling us sort of the basics, when the decisions are coming, assuming it's not 11:30 at night. And so I thought, they do a good job of sort of presenting facts and information to us. And as I say, if you've got a hard question, she would give it a try. And that's the best we could hope for, I think.
Ariane, was your hand up, or?
Yeah, I think, absolutely. And I think that the Public Information Office and Kathy was super helpful, but I think they are constrained. And we have seen in recent years it getting more difficult to find out simple things like when the justices are giving a public speech. And you have a sense that, we're people sitting here, we're responsible for where they are. And in the age of Twitter, there's been more than one occasion that I've been sitting in my kitchen and all of a sudden I see action and a justice is giving a speech to a big audience. And I find that that's problematic. And I don't think that that decision lies with the Public Information Office. I'll tell you one story. I was sitting, and Joan knows this, I was sitting in my kitchen and all of a sudden I saw Breyer was speaking, and there was plenty of Twitter action. And in fact, it was a big speech that he was giving. And the theme of it was keeping the court out of politics, which is another thing that I think might be in his mind. I mean, to give a big speech like that and then to retire, maybe he would think that those two things don't exactly match if he was succumbing to any kind of political pressure. But that speech I did not know about ahead of time. It wasn't publicized, and that's kind of problematic.
Amy?
Yeah, I think, as Ariane said, they're constrained, but it was particularly been important the last year and change during the time of COVID, when we, count on them because we're not in the courtroom seeing them and at least getting some information that way. And, as Ariane said, with that same speech on Twitter, I get an email from my editor, "Are you covering this?" Well, no, because I didn't know about it. But, just a little bit of context, because I see that we have many people here from, some are associates and some are law clerks. Kathy was at the court for 38 years. her deputy is taking over, Patricia McCabe. She's already been at the Supreme Court for 30 years. And it sounds like a really long time. That's longer than many, I imagine many in our audience have been alive. It's not that unusual at the Supreme Court for people to come and stay. You know, Washington, I think many people perceive as a sort of transient place, and institutions or people come and go quickly. And the Supreme Court is not at all like that. People come and stay for decades and sometimes their entire careers working there.
Anyone else? The opposite of retirement, of course, is appointment. And it was just this term, it seems like it was long ago, that Justice Barrett arrived at the court. I think I read somewhere that she moved into Ruth Bader Ginsburg's large chambers. Is that right? Does anyone know? Do justices not start with less desirable chambers and move up as they get senior, the way members of Congress do and partners in law firms do? Adam?
I defer to all such things to Joan,
All right.
but I would think particularly during the pandemic, nobody was eager to move chambers. So the newly vacant chambers was an obvious place for the new justice to go.
Joan?
Yeah, she lucked out because it was, they have a seniority system for every single thing in the whole world there, of course. And when a new chamber opens up, they're supposed to go by seniority to see who might want to go into that. And that would have been many justices, but in the middle of the session with COVID and a couple other things, it somehow became very convenient for Justice Barrett to be able to move in. And it is a great chambers. I think it has 3 fireplaces. It's very large. Justice Ginsburg had built in all these special cabinets, including for her jabots. So it's a keeper.
And she'll be able to keep it. No one's going to bump her next October.
No, once you're again, the court is, between seniority and you can hardly budge anybody out of there. She'll be able to keep it.
Oh, good for her. I understand that the justices resumed meeting in person for their private conferences sometime this spring after everyone got vaccinated. Does anyone have any insight into how Justice Barrett's getting along with her new colleagues now that they're seeing each other face to face? Ariane?
Actually don't. I mean, we don't get to see them. You see voting patterns, of course, but as far as personal stories, or I remember when Neil Gorsuch first took the bench, we had lots of interesting sort of give and take on the bench and the bench dynamics. But I don't have any inside scoop on how Amy Coney Barrett is getting along, or how she was welcomed, because she would have been welcomed. I don't even know if that occurred. Maybe Jonah.
Well, I mean, I'd say, remember, she's got experience at the Supreme Court. She was a clerk for Justice Scalia. I think they all sort of know each other. She knows the new justices through the Federalist Society and through other events. So it's not like she's a stranger to all of them anyway.
I remember when Justice Kagan was the newest justice, she talked about how that came with the assignment as the chair of the cafeteria committee, and she needed to revise the menu and stuff like that. I guess that's one assignment we haven't had to worry about this year. So speaking of COVID, this term, the court's arguments were all by telephone, and decisions were handed down by posting them on the court's website. How did that affect the work of the court, and how did it affect your work covering it? Who hasn't been talking much? Amy?
I mean, the telephone arguments are long. It's nice to sit at home in comfortable clothes and cover them that way, but the telephone arguments are long. It's nice to hear from Justice Thomas, who normally does not ask questions but participated fully in the oral arguments. But I think I'll be glad to get back to the courtroom. You kind of had the sense that the justices will be glad to get back to the courtroom as well. As a reporter, you're always kind of looking for the angle on the oral argument. How is it going to go? Both because you want to write a story that gives your audience an idea of what might happen, and because you're looking to write the story when the opinion comes out eventually. And there were some cases like the Arizona voting case and the California donor disclosure rules where you had a pretty good idea of where they were going, even if you didn't know ultimately what they were going to do. But I've just found it a lot harder to read the room when A, everybody gets to ask questions, and B, you can't see them and sort of read the body language. Covering them on a laptop is nice, your hands not falling off from trying to scribble down notes, and then covering the decisions, they come out every 10 minutes. And so that's kind of nice to have plenty of time to cover the opinions. Sometimes, particularly when we're in the press room, there are some justices who give long summaries of the opinions when they're in the courtroom, but there are some justices like Justice Alito who sometimes will just give a couple of sentences. This is a case coming out of the Ninth Circuit and the decision is reversed. And then you're back in for the next opinion. So I appreciate the 10 minutes, but I'll be ready to go back to the courtroom.
Do you think there's any chance that they're going to continue asking questions in seniority order one at a time? Do you think that's worked out well from their point of view? Adam?
I think there's vanishingly little chance of that. And I think that was the least satisfactory aspect of the telephonic arguments. In a real argument on the bench, the justices are doing something quite different from what it looks like formally. They're actually starting their deliberations. They haven't discussed the case with each other yet. They get on the bench, and through their questions, they start to send signals to each other about where they think the case should go. And they do that by building on each other's questions and reacting to each other dynamically. And when you have this lockstep questions in order of seniority, where you don't have that interplay, you lose that important deliberative aspect of the on the bench oral arguments. And in addition to them being long, in addition to people, having to ask a question whether they have something to say or not, it also withdrew from journalists a way you could tell who was going to win, because on the bench, the justices ask almost only hostile questions. They ask questions of the side with which they disagree. So it's a relatively simple mechanical exercise to figure out who's going to win by who's getting the least questions. John Roberts wrote about this phenomenon when he was on the DC circuit. So, good riddance to telephonic arguments. And while there's a live question about whether we might have audio access either live or right away afterwards to on the bench arguments, the idea that they'll keep this kind of ridiculous lockstep arrangement, I don't think is going to happen. One casualty of that, unfortunately, will probably be that Justice Thomas recedes again and stops being an active participant in arguments.
Another way in which these telephonic arguments have affected your work is that you're not all in the press room on the ground floor as the decisions come down, crowded in there with your colleagues. Does missing that change anything about your experience and how you were able to cover those cases, David?
Well, it feels a little bit lonely when you're sitting writing and trying to write fast. And sometimes I feel like I'm writing, I've read the syllabus, and you always worry, am I going to file something and then realize that I'm wrong on some big point? It really was nice being in the press room where we could sort of, you'd hear somebody say, what the hell is this about? Or, see something in the opinion that I didn't understand. There was a little bit of crosstalk. I've found it actually easier to do the opinions at court and get them out faster, but I do sort of miss the interaction of being able to talk to colleagues in the press room, just sort of by observations or thoughts after you've read the opinion. And so I will look forward to being there again on decision day.
Art, sorry, Bob, go ahead.
I was just going to say, I miss having a physical copy of the opinion. I find it easier to read and to mark up, and maybe that's a sign of age, and I'm not as good on screens as I should be, but I miss getting that, being able to hold it in my hand and write on it.
Joan, you wrote a piece
Yeah.
about something else you missed about live decision days.
Yeah, in fact, Art, it's funny, you and I are usually in the same room because I'm up in the courtroom. I'm probably, of all the people on this call, I have the least amount of responsibility for a quick story out immediately. Ariane is under tremendous pressure, as our other colleagues, to quickly digest something from a written opinion, whereas I'm able to be in the courtroom and hear the justices give their competing versions of what they've just done. And Art, I know that, for years I could look over and you were one of the few people left in the courtroom, that for many journalists, the pressure of getting something out quickly means that my colleagues can't be up there. And as you know, many practitioners now are just watching online. But what I enjoy about it is that I'm able to hear how the author of the majority opinion wants to spin it, sort of tell a tale that I can digest, hearing it. And then in June, we have the wonderful practice of dissents from the bench. And I noted in the story you just referred to, Art, that the very last dissent from the bench we had was Justice Elena Kagan in Rucho versus Common Cause, the political gerrymandering case, the partisan gerrymandering case. And she gave this very almost sorrowful dissent from the bench. And I would bet that if we were in the courtroom when Rabinovich came down, that she probably would have given an equally impassioned dissent from the bench to Justice Alito's majority opinion about what she thought was lost for democracy. So that's one thing that I'll want back too.
So you mentioned, Joan, that many of your colleagues are under tremendous time pressure to report the decisions. One thing that happens at least once and often several times in a year is that you get splintered decisions. You get decisions where justices join pieces of others' opinions and dissent from pieces. And Ariane, someone in your position, has to try to figure that out. Nancy or Christina, I selected an example from this term. There it is on the screen. At the end of the syllabus, the opinion has a lineup saying who wrote the opinion, who concurred, who dissented. So here's one from a case this spring that involved the appointments clause and whether administrative patent judges were officers of the United States or inferior officers of the United States. I'll give everyone a minute to read the screen, and then I'll ask Ariane. So you look at this, and you've got to, and others can comment too, you've got to figure this out in a few minutes, so you can get your bulletin online. Or was this a case of so little interest that nobody cared if it got a bulletin online at all? Ariane?
Yeah, well, that case was split like that because of the remedy, what they ultimately agreed on. So you had one set of justices making one ruling and then the other coming in on the remedy. But I think that at the end of my life, I'll really want all the time back that I have spent on ways the court could rule that it didn't rule, because I spent hours and hours thinking of every which way the court could possibly rule in a case, because I need to have, like everybody else, I need to have that language, at least fresh in my mind about what they could do. And for instance, in the voting rights case, we were dealing with 2 Arizona provisions. And there you had a little bit of wiggle room for once, because you knew that the first question was likely going to be whether those laws survive or whether they didn't. But then the meat of the entire thing was how far or what the court did with the standard that will apply to all the future cases. So you could get out the line what happened to those 2 provisions, but then you had to quickly try to figure out, is this a gut? Is this a clarification? Did they limit it? Did they send it back? where are the liberals? And I can't tell you how much time we spend just thinking about the various things. And for instance, in that particular case, the DNC thought that the laws should be invalidated, but the Biden administration didn't. So you wondered whether the liberals would sort of come in some middle ground position. That for me is the toughest aspect of the job. And maybe it's because I'm a slow thinker, but just to be able to put down every which way the court could rule. So when you do finally get it, you have a sense of where you could go quickly.
And do you actually write alternative stories in advance so that you can, pick one out of the pile?
Oh, I write so many different leads, as we call it, for every single case. I do because you never know. You never know. Like when I was back at ABC and the court came down with that healthcare case, that was a lesson for everybody that you have to read the whole syllabus when it comes to you. You have to sort of check it off as you go, and you got to get down to the bottom because the court can do what it wants to do.
Adam, do you also write lots of alternative stories before a decision?
I will typically write what in journalistic jargon is called B matters, sort of the uncontroversial procedural and factual history of the case, and then one or two tentative leads, but probably not in anything like the detail Ariane does. And, even if you have 10 minutes, and I typically have 5 or 10 minutes, that's enough time to familiarize yourself with the case and get a decent story up. In the voting rights case, I only wrote it one way, which is the way it came out, because I really had no doubts. And sometimes you just take that risk. In the patent judge case, Ariane's quite right that you could anticipate the dynamic. These appointments and removal cases all involve the conservatives wanting to make a constitutional statement about presidential power and the administrative state, but not actually wanting to do anything on the remedy. Whereas the liberals are happy with the let's not do anything on the remedy part, but they don't want to go along with the the performative signaling part on the administrative state. The other thing I'd say about the patent judge case, and this matters, is it came down the same day as the NCAA case. And that got so much public attention that in my world, at least, that buys you some time because everyone's focusing on what the Supreme Court did in case A, and that gives you a little bit more time to work on case B.
And David, because the LA Times is 3 hours behind us, opinions come down at 7 o'clock in the morning, West Coast time. Does that give you more leisure before your editors expect you to be posting something for their readers?
Doesn't help, Art. It's about 20 or 25 years ago when I was writing for a newspaper, but our people's view, people sign on at 7 o'clock in the morning and you have to get up the stories quickly. So I sort of sympathize and empathize with Ariane's point about preparing a lot of stories, a couple versions of a story. The one thing I would say I might do differently than her is if it's patent judges, I think, nah, I don't care about that enough to rush the story. The voting rights, there's a whole lot, the NCAA, the voting rights. I try to prepare a couple versions to be ready to go on stories that are really news, but I don't feel obliged to prepare multiple versions of a story that's not all that earth-shattering. What's the status of patent judges?
I would say too, Art, I'll speak for myself because the others are probably smart enough to have figured it out quickly. But my problem in the last couple of years has not been those splintered ones, but the sort of narrow decisions that the Chief Justice has written as a compromise in which he comes up with a solution that wasn't really offered by anyone. And he sort of created, and you didn't hear about it at oral argument. And those are the opinions I spend a lot of time staring at before I hit the keys on anything. And trying to hold off my editor saying, I need to read this one more time.
And on a heavy day, I'm not sure this year had any especially heavy days of opinions, but sometimes there will be 7 opinions in a day. Do you guys have the ability to call in backup support on a day like that, or do you just have to deal with the flood? Adam, I saw you had, I think, 3 stories in Saturday's paper last weekend, all with your byline.
I should do a better job at handing off some of this work, but I'm, you know, it's not really such a big beat. The court decides 54 cases. You get a little territorial about wanting to do them. The most decisions I think we had this year was 4. The only day that we had 2 big ones at the same time was the Affordable Care Act and the Fulton case about the clash between religious and gay rights. That came on a single day. That was bad. And then the last day of the term was pretty bad, although the donor disclosure case kind of paled in comparison to the voting rights case.
And the problem is we don't know when these cases are coming out. And so, you know, you don't really want to call in someone and say, you know, do you want to take this case whenever it comes down? Because maybe that's the only case that day and I want to do it. So, you know, you have to be a little bit nimble.
Well, a couple of you mentioned the voting rights case. Let's talk about that for a little bit. That came down on the last day of the term and upheld Arizona's rule that if a person votes at the wrong precinct, his or her ballot is thrown out, and another rule that makes it a crime for anyone other than a postal worker, an elections official, or a voter's family member or caregiver to collect their ballot and take it to the polling place. David, you had a story that ironically appeared on the 4th of July that analyzed that case as a part of a larger campaign on behalf of some of the justices to elevate the power of state lawmakers over the rights of voters, and suggesting that the sum of the court's rulings could basically give the Republican Party control of Congress next year and the White House in 2024. How did that analysis go?
You know, that story I think ran about a month ago, Art, in early June, not early July.
Okay.
Well, consider the last day of the term. There are 2 cases up to be decided, 2 state laws involving, it's saying we've got this rule or regulation and we're doing it as a sort of an anti-fraud matter. And the other side says there's a claim of an individual right. If you're a smart law student, you might say, well, some of the justices would think if the state is enforcing an anti-fraud, we should defer to them. Or they might think, if they don't have real good evidence of fraud, you should vote in favor of the claim of a right. But of course, once you know the parties of the case, one case has the Arizona Republicans defending a rule or regulation that is being challenged by African-American Latino voters. And the other case is from California, and it's big conservative donors fighting with the state over disclosure of their names. I think you could sort of set aside the law for a minute and say, bingo, I think I can tell you how that's going to come out. The 6 Republican appointees vote for Arizona in the one case, and Justice Alito says fraud is a very important thing, and we should defer to the state. I have a phone buzzing. And the other case, you have the 6 Republican appointees say, oh, these we're going to defer the big donors. The California doesn't really need this information to combat fraud. They can find other ways. They could subpoena it. The Democratic appointees do the opposite in both cases. So I was just making the point that there are a whole lot of cases the court decides every year, including this one, where they find a sort of and they're very good at trying to find a middle ground approach. But in the cases where political power is at stake, they are very predictable. They have been predictable for 10 or 12 years. Campaign fund, you remember Citizens United, you remember the voting rights case in, striking down Section 5, essentially. And the southern states were all part of the core of the Republican Party. The court sort of freed them from the oversight. Partisan gerrymandering, same thing. And so I just think the decisions of the last day put a different sense of this court and this term, that when political power is at stake, they divide very much along political lines, unfortunately.
You know, one thing, Art, picking up on what David said, is that, the Roberts Court with Justice Barrett on it has, it's offered us a little bit of a transition period and some unpredictability, because she's obviously still, finding her way here. But what's happened is a court that was 5-4 on those kinds of political participation issues is now clearly 6-3. When you think of, there has been no deviation on voting. I mean, we all remember Shelby County, of course, but just think of the purge case from Ohio in 2018, the voting redistricting case from Texas also that year. Those were all breaking 5-4, all had the same notion that actually was in the piece that you referred to by David, that give it to the states to work out. And the one good thing about that decision on the last day is that it was pretty clean, clean in terms of bottom line of who the winners were and who the losers would be. And if we were going to get something like that, where obviously we had a couple different people writing, and we had to sort of see what happened to measures, but it was really of a piece, and that piece would be John Roberts and the Roberts Court, in a way that I think shows how strong his hand still is on that. And even on some of the consensus ones, the compromise ones, he also took control.
Well, speaking of it being clear who the losers were, Ariane, you wondered in a story that came down, I think, a little before the Arizona decision, whether the decision in that case might spell doom for the Justice Department's lawsuit filed less than 2 weeks ago, challenging various new voting restrictions in Georgia, new limits on absentee voting, and making it a crime to offer somebody a bottle of water while they're waiting to vote, for example. Did the court in fact nip that lawsuit in the bud?
Well, I think it's so fascinating, because if you think about who is now in the Biden administration, people like Vanita Gupta, Kristen Clark, Justin Levitt, these are all people that all of us have talked to over the years, who have been in the trenches for years and years on voting rights issues. So now they're in the White House, or they're in the Justice Department, and they knew that this Arizona case was coming, right? Because there was a lot of Democrats who were worried that the DNC had pushed for this lawsuit because they were worried about this particular court. So while this case is percolating, and we all kind of guessed by reading tea leaves that maybe Justice Alito was writing it, the Department of Justice knew full well that case could impact the federal lawsuit they filed in Georgia. So what it did very carefully is, for most purposes, the case that was before the Supreme Court was based on what's called the results test, whether a law results in racial discrimination. And a separate part of Section 2 talks about the effects, or how, the intent, whether the legislatures had the intent to discriminate. So what the Department of Justice did is they said to themselves, okay, Brnovich case is mostly, but not completely, on this first test, that it results in discrimination. If we lose badly, then we're going to base our lawsuit on the intent test, so that it won't be too diminished. But what was interesting about that is Justice Samuel Alito, everybody thought that decision would really focus on disparate impact, how a certain law affected minorities and non-minorities. And when Justice Alito wrote that opinion, he focused much more on sort of looking at the landscape, look at the big picture, the totality of the circumstances, how many people were affected, how big the disparity was, and the state's interest in voter integrity. So now that we have that opinion on the books, the last thing he wrote, Alito, is he touched on the intent test. And he said, look, just because maybe there's one political player who is acting in a way that might show an intent to discriminate, that shouldn't infect the rest of the legislature. So he threw that in there. And when you look at this Georgia case, in a way, he not only narrowed the one part of the law, but he narrowed that too. And it's going to make it much harder for that Georgia lawsuit to survive. Now, there are other players in there who are challenging it, but it was a very interesting dance that happened there, because you had people in the Department of Justice who knew exactly what was at play. They feared for the decision that they got, and they decided to craft their Georgia case in a way that might allow it to continue, even if they lost pretty heartily in the Arizona case, which they did.
Before we leave the Arizona case, I had one little bone I wanted to pick with Justice Kagan. And so on your screen now, you can see a graph, yep, there it is, that she had in her dissenting opinion. So the issue was whether Arizona's rule rejecting ballots cast at the wrong precinct was a violation of the Voting Rights Act. And she wanted to point out that Arizona rejected far more ballots for that reason than any other state. And here's the graph from her opinion. In case it's too small on your screen, there's a list of all the states in alphabetical order along the horizontal axis, and along the vertical axis, and the horizontal axis goes from 0%, was 0% on the left to 0.02% on the right. And you can see that Arizona is a much longer line than anyone else. But if she had done this chart, here, I made a, ignoring copyright laws, I made a knockoff of her chart with the same vertical axis, but changing the horizontal axis from 0 to 100%. And you can see that Arizona looks like everybody else because there are virtually none in any state. So thanks for the screen sharing. We can go back to the panel, I think. Adam, I know you like statistics, you use them a lot. Was that an example by Justice Kagan of using statistical information in a graph in a misleading kind of a way, or do you think that was perfectly fine?
I don't think so at all, Art. I think it highlighted the distinction between her approach to the case and Justice Alito's approach to the case. Justice Kagan's approach was that a difference in percentages matters. Justice Alito's approach was that only raw numbers matter. If you think about the sacred right to vote, you might think that if minorities are being discriminated against at twice the rate of white voters, it oughtn't matter whether that's 5 or 10 or 100. But let me read you the text that comes right after that graph, because she was perfectly transparent about what she was saying. She said, votes in such numbers can matter enough for Section 2 to apply. The majority, Alito, obliquely suggests not, comparing the smallish number of thrown out votes to the larger number of votes cast and counted. But elections are often fought and won at the margins, certainly in Arizona. Consider the number of votes separating the two presidential candidates in the most recent election in Arizona, 10,457. That is fewer votes than Arizona discarded under the out of precinct policy in 2 of the prior 3 presidential elections. So I think it's perfectly good legal advocacy to make your point that what matters is the percentage difference, not the raw number difference, and to acknowledge that the majority has a different view. And if you want to put that in graphical form, it's no different than writing it in a sentence.
Anyone else want to comment on that, or does Adam get the journalist word? Bob?
I thought another interesting thing she did in that was about statistics. I think that Justice Alito said something like, you know, a law that 99% of people comply with can't possibly be discriminatory. And she wrote that if there was a law that said we're going to automatically eliminate 1% of Hispanic voters, that no one would think that that was a proper thing to do. And so, you know, they're both smart people with good arguments on their side. And I thought that that is an example of an opinion in which it was just sort of, you know, round for round, point by point, opinion, majority opinion, and then rebuttal. And, you know, if a reader read the whole thing, would have a, you know, pretty good idea of this case and what was at stake.
I think another thing that she did several times is she cited Ruth Bader Ginsburg, because of course Ginsburg had written that roiling dissent 8 years ago, and Kagan felt to me like she was picking up the mantle and citing that again. And it's interesting because almost every term, Kagan has a marvelous sense of humor, and very often she finds a way either on the bench or in her opinions to use that. And this term, I mean, there was a couple of times when she said you're comparing apples to watermelons, I think, but you didn't see a lot of Kagan's humor here, and maybe that's because we weren't on the bench. And that opinion was striking for just her fury.
So another important, or at least potentially important case this term was Mahanoy Area School District against BL, where the court ruled 8-1 that a public high school couldn't punish a student for posting a message on Snapchat from a local cocoa hut on a weekend saying, fuck school, fuck softball, fuck cheer, fuck everything. But I wonder, do we actually know anything more about the free speech rights of public school students today than we did 2 months ago? Or do we only know that if you post that on Snapchat from Cocoa Hut, you're okay? Amy?
We know a little bit more. This was a really fun case to cover. I went back and looked at the oral argument transcript again, and Justice Breyer, who wound up writing the majority opinion in the case, said, well, I'm frightened to death of writing a standard. And in the end, the court didn't really write a standard. The court rejected the Third Circuit's position in this case that schools can never regulate off-campus speech. They said it may be appropriate for schools to regulate off-campus speech to deal with problems like severe bullying or threats to teachers and to students. And I also thought, you know, this was Snapchat at the convenience store on the weekends, but it was also, I think, in some ways sort of appropriate that the court was hearing this case at the end of the pandemic, when you had millions of students around the country who'd been doing school, virtual school, for almost a year. But the court did sort of outline factors that they said should influence decisions by school officials, whether or not they're going to regulate speech. And one of the big factors in particular, they said, you know, off-campus speech, it should generally be the parent's responsibility. So we don't know exactly how this is all going to play out in the future, but we do know a little bit more in the sense that we know that there is at least, there are some windows in which schools will be able to regulate off-campus speech.
And there really are two forums in which this will play out. Amy's described the legal ones, and in future litigation, it may be that courts will struggle to apply the, you know, Justice Breyer's characteristically mushy factors. But these cases also have a role in the public consciousness. They have kind of a didactic function, which is apt given the fact that it's a school setting. And I think school boards will just hear, wait, the Supreme Court said you can't punish social media posts? And that may be, in a way, the practical holding of the case. And the school board may not go to its lawyer. It may not read the case. It may just know the Supreme Court said something And it will at least start with the question of, is what we're trying to punish as bad as or worse than what this kid did? And so this is one of those rare cases that might enter the public consciousness kind of at a non-doctrinal level, on an anecdotal level, and be effective as a consequence.
Let's hope. There were a couple of cases this term that was supposed to be blockbusters, but turned out not to be. In Fulton against Philadelphia, on the question whether Catholic social services could refuse to place foster children with same-sex couples, the court ruled for the church, but on very narrow grounds. California against Texas was the third challenge to Obamacare and went away on the ground that the plaintiffs lacked standing. But in both cases, Justice Alito was very unhappy with the result. Ariane, you wrote a piece about what's going on with Justice Alito. Why is he so agitated about these cases that turned out to be, didn't go against his view on any major issue?
He was fascinating this term. And one case that wasn't on any of our radars, but I thought it was so interesting. It was a case where two parents wanted to bring an excessive force case against police officers because they said their son died in prison because he was shackled and put face down. And the court issued a per curiam opinion and basically said, send it back down. They kept it alive. And Alito was furious. And he said, I don't know how this should act, but we need to roll up our sleeves and we've got to decide these cases. And then you saw him, so there he's agitating to go further. And of course, you saw that in the religious case, because there his concurring opinion was like, he said that the majority opinion was as if it was written on paper that will disappear, paper that you buy in a magic store. I mean, he was really furious that they didn't go further. And then in the ACA case, of course, he fought back not only on the standing, but on the merits. He bought the argument that the entire law should fall. And then, of course, at the end, you had his VRA opinion where he was really so muscular. So he, to me, don't forget, this term started out with Alito joined with Thomas calling for the court to look at the Obergefell opinion again. And then midterm, he gave a speech where he said, which, it's not so rare, but he gave a speech where he basically said that religious liberty is under attack. You had a sense that he was a driving force in a lot of the COVID emergency orders where the court sided with houses of worship. And in one of those emergency orders, in fact, the court moved the law without a case being argued. It's unusual to have that occur in an order when there's no arguments or briefs. So he was fascinating this term. You had a sense that he was pushing it, and he feels like we've got to roll up our sleeves and decide the cases in front of us and not namby-pamby around.
Art, I thought the press coverage on the Fulton case on religion could be questioned, and I was part of it. So, this was a situation where you had the Catholic Archdiocese fighting with Philadelphia over the Philadelphia's program. Remember, this was a city program, and they wanted to participate and get public money, but they didn't want to follow the city's rule. They won 9-0. And as Ariane was just saying, Sam Alito writes this very strong dissent and said, we should have gone much further. The liberal justices sort of signed on to it. I thought if the liberal justices had dissented, and it's almost as though the sort of angry concurrence by Sam Alito sort of drove the coverage. Says, "Oh, we didn't go very far." Well, my impression is that religious liberty claims are almost always to win in this court. It's only the question of, they have to find some avenue to rule for the religious liberty claim. Chief Justice Roberts is pretty good at finding some reason to say, oh, too bad, Philadelphia, you lose. You've got this rule that says you could have exercised discretion. Anyway, it's a little strange phenomenon that you have a case where the city defending a ban on sexual orientation discrimination loses 9-0, and the religious liberty claim Winston I know, they get to stay in the city program, and it's treated as, oh, this was a very narrow, this didn't decide much. I sort of thought that this was a bigger win for religious liberty than a lot of our stories suggested.
I agree with David. I think the Alito concurrence was sort of the opposite of the old Scalia dissent, which is the sky is falling. You know, the next thing you know, we're going to have gay marriage. And he turned out to be right about that. Here, Alito's undercutting what is a significant win for the religion side, and a very surprising vote from the liberals, and the actual making of law. I mean, the case was vaguely similar to Masterpiece Cake Shop, the Colorado baker who didn't want to bake a cake for a same-sex couple. But here you actually have law, which is that you apply strict scrutiny whenever there's an exemption available to anybody, even if it's never employed. Religion gets a most favored nation status. That's a long-term project of the forces of religion in the courts, and it was reflected in some of the shadow docket orders on COVID, and now it's in a majority opinion. I think this was a pretty big victory for the religion side, oddly undercut by the Alito concurrence, saying they should have gone further.
But you know what I think that is part of that was, I think it's an age-old battle between Justices Alito, Gorsuch, and Thomas to a lesser extent. I think it's mostly Justices Gorsuch and Alito really do not like how John Roberts sidesteps things here, because it was a win. And I think there's some truth to what David's saying, that this was of equal significance to what they did on COVID to privilege the religious objectors. But what they actually had completely right was what John Roberts did. It was a classic special of the chief. He sort of rewrote what the actual problem was here with this contract and the exemptions for people who applied. And of course, the liberals were going to go along with that, even though they were thinking, well, that's not really what was before us, but we'll take it. We will take whatever we can get in this area of the law. And Justice Gorsuch actually also wrote a concurrence that didn't get half the attention that the Justice Alito one did, but Justice Gorsuch took the chief to task on how he kind of made up the terms of this contract, which, you know, was a little too in the weeds for most of the coverage, but was, I think, the source of some of the anger and frustration on the part of at least those three justices on the right wing.
I think Alito's dissent kind of gives or concurrence kind of gives the liberals cover for not having written, because it makes it sound like, oh, this was just written on magic paper and you have to change the contract. But I talked to several conservatives afterwards, and they were stunned that the liberals hadn't said anything, hadn't even written a word about it.
Yeah.
Just point out too, if we're when we talk about Justice Barrett's influence on the court, these COVID restrictions is the clearest example of where she's changed the court. Before, when Justice Ginsburg was there, the Chief Justice joined with the liberals to say these COVID restrictions are up to local officials. We should not interfere unless we've got a really good reason to do it, and the churches lost. And as soon as Justice Barrett came on board, it switched just the other way. You know, these religious rights are so important; they can't be undercut by local officials, no matter what. And they really looked for ways to overturn them. And so I think that shows the biggest impact so far that she's made on the court.
Adam, you used the phrase shadow docket, which I don't think I'd ever heard until about 2 years ago, and maybe some of our audience isn't terribly familiar with it. Can you explain what the shadow docket is and why it's become such a big deal?
Right. People tend to focus on the court's merits decisions. They're the decisions where the court decides to hear a case, has full briefing, has oral arguments, takes months to give birth to 80, 100-page opinions with concurrences and dissents, and it gets the full attention of the Supreme Court. Other kinds of cases reach the Supreme Court on emergency applications, saying a lower court has done something terrible. You need to issue a stay, Supreme Court, and I'm going to give you a 15-page brief, and please decide by Tuesday. And the court calls for a response, doesn't hear argument, doesn't have anything like full deliberation, and issues orders, often very consequential ones, often without any reasoning whatsoever, saying stay denied, stay granted. Sometimes there's a little bit of reasoning, sometimes there's a concurring or dissenting opinion, and matters of great consequence, like the COVID issues Bob was talking about, or an eviction moratorium just the other day, or countless voting cases in the run-up to the election, were decided on these emergency applications that people refer to as the shadow docket. And it's a really problematic way for the court to act. It spiked in the Trump administration very decidedly because judges, particularly in blue jurisdictions, were issuing nationwide injunctions, and the Trump administration would run to the court, and the court would often see eye to eye with the Trump administration. But nonetheless, it's hard to take account of these cases in a systematic way, the way you can with the 54 cases on the merits docket. And a lot of work is being done in them. I think maybe we'll get less of it in the Biden administration, but it's hard for journalists to know how to cover. And they also, these rulings on the shadow docket emergency applications will almost uniformly come at 7 o'clock at night, 9 o'clock at night, 11:30 at night. So you're not going to be able to give it the attention it warrants for that reason too.
Now, one of the shadow docket cases you just mentioned was the eviction moratorium. It came down at the end of the term, and I don't think it got a lot of public attention. The question was whether the CDC's nationwide eviction moratorium was lawful or not, whether it was beyond the authority of the CDC. A district judge said it was unlawful, but stayed his orders so that the government could appeal. It went up to the Supreme Court, which split 4-4, with Justice Kavanaugh casting the deciding vote. And he wrote a 1-paragraph concurrence in which he said, it is unlawful, but I'm not going to lift the stay, and I'm going to allow the moratorium to remain in effect. Was that, Amy, was that as weird as it sounds when I describe it that way?
I mean, he explained it because the idea was that they didn't want everything to sort of happen. The idea was that it was going to allowing, I'm trying to remember his exact words.
It was going to expire at the end of July.
It was going to expire at the end of July, and sort of putting it back into effect would sort of create chaos. The whole idea was to allow things to happen in kind of an orderly fashion. And so he was going to keep it in place until the end of July. I think he also included language about, let's not let this happen again. We're doing this on the understanding that it's not going to happen, that it will not be further extended.
And is it any surprise to anybody that it was Justice Kavanaugh taking such a practical, legalities aside, we want the world to work smoothly approach to an important case like that, and not anybody else? Everybody else apparently split. We don't know who voted which way, but apparently, viewed it as the law should control.
No, that's not a surprise, Art. I mean, the one thing we've learned about Justice Kavanaugh, he's very concerned about the practical impact of decisions. He talks about it in the arguments. I think Neil Gorsuch, when you hear him talk, he's very focused on what the law is and doesn't care. He doesn't want to hear about the consequences. Somebody said, "Oh, this is going to really cut." If you say a third of Oklahoma is an Indian reservation, it's going to cause a big cut. He almost says that's not our business. That's somebody else's business. We just get the law right. Justice Kavanaugh is very focused on the practical side of the legal decisions. What's going to be the impact? So I thought this was a classic. He sort of agreed with his conservative colleagues that this regulation was probably illegal, but on the other hand, it's going to expire and end in another month. So I'll vote to let it stay for another month. A very practical decision, very much in line with Justice Kavanaugh's approach to a lot of things.
I thought sort of in his wheelhouse as a former member of the DC Circuit who deals a lot with government agencies and government programs and sort of knowing, you know, let's just get this over with. And if they try to do it again, we'll shut it down.
So before we run out of time, Jonah, I said I was going to ask you if you're working on your next book. Are you, and can you tell us anything about it?
I'm always working on a next book. I'm doing more of a group portrait this time. I kind of used up all the most interesting ones, so now I've got to go a little broader. Long range, Art, long range.
Okay, well, I'll ask again next year and
Yeah,
see you are.
thank you.
Sure. We have one question in the Q&A that says, since starting law school, I've noticed that many major media organizations publish legal stories that are incorrect. In some instances, it seems likely they don't fully understand our legal system. Do you see that becoming more common? Do you think it's a problem? I wish this anonymous attendee had given us an example or two, and maybe he will in the box. But is that a phenomenon that you're aware of? Do you think it's getting worse? Anyone?
You're asking the wrong people, Art. We're the ones who must be putting out the incorrect stories.
I guess.
But that's reading the coverage of my colleagues. No, I don't see a lot of stories that I think are incorrect on either the facts or the legal holding. There's always a debatable, as we've been discussing, trying to assess what's the impact, what's the significance of a decision. That's very much a matter of debate and judgment. But I don't see any legal stories that I think are actually flatly incorrect on the law.
So
You know, one thing that I see a lot, and I caution my colleagues about, is when the court doesn't take a case, you have to remind everyone that that doesn't mean that the court has ruled on the case. It means that the court, for some reason that we often do not know, decided this wasn't ripe or ready for them. And so I always, I do have to caution my colleagues a lot that, you know, when the court doesn't take a case, it doesn't mean that they have weighed in on the merits of that case at all. And that's something that I do see reported incorrectly a lot in sort of shorthand in radio or TV or you know, other media as well.
So in the chat box, maybe the same person gives an example. He says, for instance, the headline was "Athletes Win" in the NCAA case when all they got was access to scholarships, but not actual compensation or sponsorships from the court's decision. The NCAA later changed its rule. So, I mean, is that a good example where the headlines "Athletes Win" and was that misleading?
Well, I think if you look at that story, the athletes did win, but I think every single person looked at what Kavanaugh wrote separately, and Kavanaugh alone thought that the court should go much, much further, and the writing was on the wall. And I think that he really attacked sort of the raison d'etre of the NCAA. So. Right, the win was limited, but Kavanaugh sort of laid out the groundwork for what's coming.
Another questioner wonders if you have any thoughts on why the court chose not to hear the New Hampshire against Massachusetts tax case. As I recall, that was a case about whether people who were working at home because of COVID could still be it could be taxed either where they were working at home or in the office that they were no longer physically going to. And it is possible the court just wants Congress to resolve the matter, asks the questioner. Any thoughts on why they denied cert on that potentially very important case? Important, although short term, I guess. Okay, no No special insight there. Here's another question. Are there any resources, digital, print, podcast, etc., that you'd recommend for law students who would like to learn more about the topics the panel discussed today, the shadow docket, for example? Well, of course, the answer is you should read the New York Times, the Washington Post, the Los Angeles Times, listen to CNN, and read How on the Court. But other than that,
And I would add that SCOTUS blog is really the key resource here, both in terms of materials on the court and summaries of decisions and previews and recaps and symposia. I think, Amy, you all had a symposium on the shadow docket, didn't you?
Sorry, I think that's right. Steve Vladeck, the University of Texas, also tweets and writes a lot about the shadow docket.
yeah, I certainly agree with Adam.
The court's own website has gotten a lot better in the past couple of years. And listening to oral arguments can be quite interesting.
I also think sometimes students don't sit down and read the opinions and the dissents and the concurrences. And you got to do that. Maybe not in the heat of the moment, but to sit down and read it and reread it. I'm thinking of Kagan in the VRA case. I mean, she's writing like a professor. And I don't think enough people really read those cover to cover, because boy, there's a lot there.
So another question asks, what are the top 3 books you would recommend to someone to learn more about the court, the justices, the cases? Maybe I should ask.
Don't ask Joan.
Joan, you've already.
Anything that Joan has written, any one of Joan's books, maybe starting with the chief.
Thank you, Ariane.
Putting Joan's book off the table, are there any second choices?
Scorpions by Noah Feldman is quite accessible. The Nine by Jeff Toobin. Simple Justice, A History of Brown against Board of Education. Those are good books.
The Brethren is really, it's old, dated, but really good too.
Or Just Mercy by Brian Stevenson. It eventually comes up to the court, but it's such a great book. Gideon's Trumpet was an old standard, like the Brethren in some ways, but it's such a different court now.
Yeah. Well, maybe a good way for us to wrap up is to talk about the White House Commission to study the court. When Merrick Garland's nomination was blocked and Amy Coney Barrett's was rushed through, many progressives started agitating to pack the court or to make other changes that they viewed as a way to prevent disaster. And President Biden appointed this commission to study the court, which has been busy holding hearings. Have any of you been following the commission? Do you think it's likely to do anything useful, or is it just window dressing? Anyone? David?
This is a question for Amy, I think.
Well, Amy actually asked me not to ask her about this because she has testified.
Oh, because she testified.
Oh, she actually knows something about it.
Right.
Since I know nothing about it, let me say something. You know, the commission is not even being asked for recommendations. It's just studying the question. And a blue ribbon commission is a classic Washington response to doing, you know, not wanting to do anything, but wanting to seem to be doing something. The leading candidates for things to do about the court are expanding its size, which at least inside the court, and including comments from Justice Ginsburg before she died and Justice Breyer recently, is not a popular idea. It would, you know, it would be a response to a political critique of the court, and it would be a political response. So it's problematic, although it wouldn't be hard to accomplish. That could be done by statute. A much better reform, which would mirror the experience of almost every developed democracy around the world, would be term limits or mandatory retirement ages. But that probably requires a constitutional amendment, and that means it's a non-starter.
You know, Art, I'll merge the two of the questions you asked. The one thing it's good for, I don't think it there will be any movement from it. But if somebody really wants to know kind of the ins and outs of how the court works, the testimony has been really fascinating to read because it does get down in the weeds. Amy, of course, has her material on the website. Steve Vladeck, whose name has come up in connection with the shadow docket, has something deep about the shadow docket. Other people, Michael Dreeben talks about the role of the Solicitor General. They had the materials that go up are actually a good window into how things work. They're not such a great window into what kinds of improvements and reform will happen going forward. But they are at least, they have an educational element. Let me put it that way. In terms of anything that's daring, it's not a daring group of people at all. It's a group of people who are mostly part of the establishment. And then the others who they have drawn on beyond the core group that we know are very much establishment people who I don't think really want to rock the boat much.
Well, in case anyone listening, including me, is interested in looking at some of this material, does the commission have a website where they post it all?
Oh, yeah. In fact, Amy could probably jump in there, but they definitely have a website that you can go to, and you can not only read the materials, you can watch the videos from their testimony.
That's right. It's all on you can get it through the White House's website.
Yeah.
Great. Well, we're almost out of time, and here's a good last question. The writer asks, do any of you have any advice for young writers? I'm not clear if they're talking about journalists who cover the court, journalists in general, or writers in general, but you're all writers. You've got 2 minutes, so that's 30 seconds each, something like that. What's your advice for aspiring writers? Ariane?
I would say the best thing you can do is write. Not wait for the perfect time or the perfect opportunity, but the only way that you can do it is to find some outlet and to start writing, because you only get better after you start doing it. So don't wait for the perfect opportunity to be presented to you.
And if the question is not about journalism and it is instead about legal writing, wow, like Reed Roberts, Reed Kagan, that some of the writing is really excellent. And some of the briefs, read a Paul Clement brief and compare that with somebody else's. They're just, when a brief is good, it's extraordinary. So pay attention to that. Let's start with the justices.
Avoid cliches, avoid tired formulations, avoid jargon, try to write like you're speaking the English language.
That's Amy's slogan.
And I would add to Ariane, I would add reading good, not really good non-legal writers as well. I think that it just to sort of get in your mind that, the Chief Justice, Justice Kagan, Justice Barrett, they're all fantastic legal writers, but you want your writing to read like non-legal writing as well.
Yeah, I would agree with that. I love many of the justices whose names have just been mentioned by Ariane, but I do think it's a bit of an occupational hazard that we do have to read so many legal opinions sometimes because there's so much other exciting writing out there that can enhance what we have.
Okay, my clock says 4:30. We could go on for an hour, but we won't. Thank you all very much for this wonderful panel. I hope the audience appreciated it, and I'm going to hand it back to Nancy.
I just want to echo the thanks. This is just a fascinating conversation. I hope you all appreciate how exciting your jobs are and how much people love hearing what it is that you do and the things you're able to do. I want to say a huge thank you to Art for putting together the conversation. I know it takes a lot of research and thought to ask the right questions to generate the conversation. And I really look forward to future years where hopefully we can gather over lunch and be in the same room again. So thank you for spending the first